Uh, let's see. Good morning to those who just came on. Do we have any questions, transactional questions that you're in the midst of and you want to ask while we're all here and have collective wisdom? Sarah's got 2 open escrows. Congratulations. I hope they proceed to closing. And these are her first transactions. So she's got some interesting things going on as a new agent with new escrows. One of the things she asked about was the owner had, or the buyer, she's representing a buyer, had scheduled did have a home inspection and then decided to have a second home inspection. Well, Sarah was able to attend the first one, but had a conflict for the schedule of the second home inspection and wondered if, there was a firm policy that agents had to attend all home inspections. And it's not a policy, but it is a best practice. It's probably would be called an industry best practice that the buyer's agent attend the inspections along with when they're being done, if possible. But it's not always possible, so it's not a fatal flaw. If you ever got pulled into court, you say, well, what is your practice? Well, my practice is to attend the inspections. That's what I do 95% of the time. And then, in this case, I couldn't. But you get the results. You certainly, if there's a written report, you certainly review the written report. If there's no written report, you might ask the buyer for permission to speak to the inspector. So you get the feedback from the inspector, and you make notes and you put them in your file, and everything's taken care of that way. So that sound right, Sarah? Okay. Not to, don't get too worried about it. I always say our business isn't heart surgery. No one's going to die on the table. We'll figure it out. We had a question come up just yesterday about the scenario is our agents are representing a buyer. Mari's asking why there were 2 inspections. My understanding was well, why don't you explain, Sarah? Why were there 2 inspections?
The buyer wasn't happy with the first inspection, even though she hadn't received the report. So, and it's her ex-husband, who she just divorced, is a well-known home inspector and was initially supposed to perform the home inspection, and then at the last minute backed out, and then now has decided that he is going to do an inspection for her. So it was kind of a unusual situation. And I will say that the inspector that came out, and granted, this is my first time meeting with an inspector, seemed a bit new. And so maybe that's why she felt that way. But yeah.
Okay. Yeah. I mean, if she was married to a home inspector, she probably had high expectations.
Yeah.
Okay. Well, thank you. So the scenario is our agents are representing a buyer. They write an offer on a property. The seller, through their agent, submits a counteroffer. Seller's counteroffer number 1, and then the buyers submit a buyer's counteroffer to the seller's counteroffer. Buyer's counteroffer number 1. And then the selling agent or the listing agent calls our agent and says, it looks like we may be getting another offer.
Oh, fuck.
So this got communicated back to the buyer, and the buyer said, well, I don't want that to happen. I'll just accept the seller's counteroffer. So that's the path they were going down. Does anyone want to venture an opinion whether they can withdraw their counteroffer and accept the seller's original counteroffer? Rob's shaking his head yes. Any other opinions? Amy?
Wouldn't that depend upon how those were written up? That would be stated within the counters, wouldn't they?
Okay, that's an answer. Anybody else want to venture an opinion? Shannon?
Isn't a counter become part of the contract? When it's huh? When it's signed, isn't it become part of the contract? I mean,
Yeah, okay. In this case, the seller had not reacted yet to the buyer's counter offer. And the buyer wanted to withdraw it and accept the seller's original counter offer.
Oh, sorry, I misunderstood the question. From my understanding, you cannot flip back once it's been signed, correct?
Okay, yeah, that's the correct answer.
Sorry, I didn't understand the question at first.
Okay, no worries. So we're going to go look at a useful resource for all of us, and which we pay for dearly. We pay our NORBAR dues, which cover our CAR dues and our NAR dues, and we pay for this stuff. So where we're going to go is the CAR website here. So this is the home page on the CAR website, right? I'm going to go up here to Transaction Center, and that gives us a bunch of bars across the top here. And one is risk management. We're going to go to risk management. Okay. And then there's a bunch of legal things, live webinars, podcasts, legal tools. So this is a bunch of risk management stuff that CAR provides us, in addition to having our own risk management legal team as well. So we're going to go into Q&As. I've always loved the Q&As because they're structured as Q&As, and they're very helpful. So this little chapter now, we're into legal Q&As and disclosure charts. If you've never looked at the disclosure charts, they're very helpful. There's a sales disclosure checklist, an REO disclosure checklist, lease and rental disclosure checklist, all these charts. And it tells you when you need what forms in what transactions. So that's a very helpful resource right there. But down here under the Q&As, they're set up by category. And you can see there's advertising ones here on the far left hand is under category. There's advertising, there's agency, arbitration and mediation, Board of Realtors, broker practices, and real estate office issues. A lot of these, you wouldn't get into as an agent necessarily. Commissions. And then we're into a section called contracts and forms. Okay. And that's where I want to land here for this particular question. So under contracts and forms, there's buyer's interest letters, buyer representation broker compensation agreement, contingencies and contingent removal. And here we have contract law and real estate transactions. So we're going to dig into that. And under this, we have questions around the basic forms of contract. And this is some of the stuff comes from our training and our license training. What real estate contracts must be in writing? Can a listing agent accept a buyer's offer and a purchase agreement by signing the his or her own name, followed by a per telephone conversation with the seller. So these are all good questions. The one, here's one on mental capacity, parties capable of signing contracts. Minors, mental capacity and incapacity, intoxicated or drugged. We had a seller one time who came to the contract signing totally drunk. We had him sign it anyway, but it worked out, but it was kind of a weird scene. Okay. Is there a irrevocable offer? That's often a question. Because can you make an irrevocable offer? And it's called an option contract. Yeah. Okay. And then it does have questions about writing an option and so forth. But here's the question we're looking for. How does a counter offer affect an offer? So the answer is a counter offer constitutes another offer. For example, the buyer offers A, B, C, and D contract terms. The seller counter offers by accepting buyer's offer subject to E and rejecting A. Thus, in essence, the seller is offering B, C, D, and E. The buyer accepts, those become the terms of the contract. It's important to keep in mind that a counteroffer constitutes a rejection of the original offer. Once an offer has been countered, a party cannot go back and accept the original offer. For example, the buyer writes an offer and the seller writes a counteroffer number 1. Buyer then writes counteroffer number 2 and sends it to the seller. Then buyer learns there's another interested buyer and promptly accepts counteroffer number 1. That won't work. By writing and delivering counteroffer number 2, counteroffer number 1 cannot be reactivated because it has been legally terminated. So that scenario is exactly what we had. So what does the agent do representing the buyer then?
I have one question first. So the buyers, okay, they submitted their counter and the seller signed it, yes?
No.
No, the seller didn't sign it. But once the buyers delivered that counter, that basically countered the original offer, right?
Yes.
Okay.
Yeah, that terminated those.
It terminated, yeah.
Terminated that original counteroffer.
Okay.
All right.
Original.
Yeah. So you
Yeah,
can't go back and resurrect that thing.
okay.
So what does our agent do now? And the buyer who still wants to buy the property, what do they do?
Could the buyer write a counter offer almost identical to the original terms? And no, okay.
No, because everything is dead. Everything's expired at that time. Okay. So what do? They write a new offer. Just start from scratch, write a new offer because your original offer is dead. If you want to refer to the original offer and say original offer is hereby withdrawn, you can reference that, but you really don't need to because it's all kind of moot anyway. Just so that's what we've done. Our agent has done is wrote a new offer for the buyer and submitted it, and we'll see where it goes. Amy, you had a question or a comment?
Gary, can you hear me okay?
Yeah. Mm-hmm.
Can you hear me okay? Good. Okay. Sorry, I'm in my car. Yeah, I had this happen too, where, we had the back and forth counter offers and my buyer was concerned that she would lose the deal. And because of the first right of refusal, we explained that to her and she felt much better.
I'm not sure I understand the scenario, but
it's exactly the same scenario that you described.
okay. So she wanted to withdraw her counteroffer and accept the original seller's counteroffer?
Yeah, she was worried since the other buyer, or
Right.
sorry, yeah, since the other buyer was in the picture, that she would lose out on the deal since, or she was worried that the seller wouldn't accept her offer anymore because of the other buyer. But we assured her that you know, she had the first right of refusal. So she could, it's not like, you know, oh no, he doesn't like your offer. He likes the other buyer better and now you're out, right?
Well, she would be out, and there is no first right of refusal created in that situation. Until you have a binding contract, there's no first right for anyone.
Okay, so this buyer was different. She actually, she had a binded contract where she upped her counter offer. Maybe the scenarios are a little different. I apologize.
Okay. I mean, if you have a ratified contract and let's say you have a ratified contract and you want to write an amendment to the
Right,
contract.
right.
Okay.
That's what it was. I don't know if you
Okay.
recall that one.
Yeah.
Yeah. Okay.
Okay. And
Thank you.
yeah, and that's why we use that amendment form now instead of an addendum, because the amendment form has an expiration date in it, just like a counteroffer does. So if the party who created the amendment doesn't get an acceptance from the other party, the other party can't cancel because, you know, that thing expires and it goes away, poof, and the original terms still stand. If you wrote an addendum would be essentially a counteroffer, and all of a sudden that seller could say, sorry, I don't accept your counteroffer, deal is off. You don't want to get in that position.
Right. Thank you.
Right. Amy, you just received a reverse offer from a listing agent and her client. I am assuming we can submit a buyer counteroffer in our response. What's a reverse offer? I'm not even familiar with that.
It was so weird. So I got an email from an agent with, she called it a reverse offer. So her seller submitted some offer terms and wanted to know if my client would be interested in accepting that offer or to begin negotiations on that offer. So they initiated the offer on this property.
Did the seller know the buyer?
No, they just submitted it to me. They knew I had two interested parties.
Oh, okay. And did they like Rob is asking, did they submit it on an RPA?
Yep.
So
The
they
agent
wrote up an RPA with your client's name in it?
My client's name is not in it because she doesn't have it. And you know, they put in different terms. I'm trying to pull it up right now. Actually, can't seem to pull it up. And I thought, well, this is interesting.
No. Yes, it's very interesting. And
I mean, I would counter it because I didn't like any of the terms, and I don't think that in this case a loan wouldn't apply. They were going to pay cash, so I'd have to counter all kinds of stuff on it. But I think she was just trying to open up negotiations because she didn't like my initial number that I was going to drop for my client. But so would I just respond with our own RPA and?
Yeah.
I mean,
Yeah,
doing counters and crap would just be too complicated.
that RPA that they submitted to you, which they're calling a reverse offer, which is something I've never heard of, just isn't valid at all. I mean, it doesn't have a buyer's name in it. It doesn't have any terms the buyers agreed to. Was it signed by the seller?
Yes,
Wow.
yes. It was
Don't,
signed by the agent.
okay. Easy, simple rule here. Don't do that. Don't write that kind of thing. If the buyer is not volunteering to write an offer, you can't write an offer for them. You know, I don't even know what kind of agency relationship that listing agent would have with the buyer because they're writing the buyer an offer.
Well, but there's no buyer.
The buyer hasn't asked for it.
Yeah, it was weird. I guess it was a way of opening up.
Yeah.
Or enticing the buyer to say, hey, we're willing to work with you, but unfortunately not enough. But it was weird. So
no, it's weird and it's not good practice. It's not it's not legal. I just wouldn't do that at all. So
yeah, the seller is highly motivated. We've submitted a reverse offer. On behalf of the seller, I am presenting to you and your client a special offer, a reverse offer. The seller is motivated to find a buyer since she understands it's in need of work, blah, blah, blah. Attached, you will find a purchase agreement with standard contingency timelines and estimated 5% down, credit towards closing costs. Hope you will receive this interested clients and join in a conversation of negotiations. And she's attached an RPA with the seller's signatures.
Wow, 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 wow. No, I mean, if you wanted to do that, you know, we've talked about letters of intent in the past. And often the buyer will write a letter of intent with terms that they would put in an offer and see if this, you know, it flies. You know,
Right.
you submit that to the seller and the seller's agent, and you know, if the seller says, sure, I'll accept those terms, and you sign a letter of intent, then you can move forward. But you certainly wouldn't write up an RPA for a fictional buyer like that. So that's not there's no such term as a reverse offer that I've ever heard of. So.
Did it come with a big red light and a voice saying, danger,
Blinking red
danger,
light.
Will
Right,
Robinson, danger?
Right, right. Steve is
I'm going to call the client. It's kind of funny story how I even landed on this person, but I'm going to call him to say, hey, they are really anxious to sell this property.
yeah.
Here's what I would recommend if you're interested.
Yeah.
And we'll just present our own offer. I'm not going to go off of that and counter it and do all that crap.
Oh, no. It's not valid. You shouldn't counter it. It's
yeah, I guess it was bizarre to me. And anyway.
Yeah. Well, thanks for
Good
sharing.
example for this morning.
Yeah, no, it's perfect. Thanks for sharing that. Steve is asking about our original question. What happens if the roles are reversed? The seller presents a counteroffer number one to buyer. Before the buyer accepts or counters, another offer comes in. The seller has the right to rescind that seller's, that counter. Yes. A party can rescind an offer they made anytime prior to its acceptance.
Correct.
So that's all well and good. But what they can't backtrack to a prior counter offer or something like that, they can just rescind their own offer. Okay. Any further questions on that? Okay. So use that CAR, the Q&As, go in there and look at all the topics. The Q&As are really helpful. They cover a lot of topics. I mean, when I have a question, someone's asking me about Prop 90 or Prop 60 or 1031 exchanges and things like that. Most of the time, CAR has a Q&A about that, and it's helpful to go in there and look at it. And you pay for it, so go ahead and use it, And I know a lot of agents who use the CAR hotline. I personally, I don't think I've ever called the hotline. Has anyone here called the hotline from time to time? Yeah. Okay, Rob, how was your experience with the hotline?
It was actually really helpful. I can't remember what I actually called about, but I remember it being a really quick and easy phone call.
Well, that's good. Yeah, I mean, if you have something that you want a legal answer on and you can't reach Randy or me, try the CAR hotline. We are generally going to be in, I mean, those are real estate attorneys. We're generally going to not argue with them about what kind of answer they give you, as long as they understand the issue properly. Curtis says he's used them, but it did take a little while to get an answer. It just depends on how busy they are. Okay, let's see. Oh, a question came up about a buyer is still in their contingency period and it's reaching its end. And our agent who's representing the buyer is a little concerned that the seller might give them a notice to perform. And we're going to go in here to look at the RPA for a minute. So the NPB, it's called, Notice for Buyer to Perform, is something that a seller can give to a buyer under the terms of the contract, RPA. So let's look at this. Okay, now we're down here and I think we're in paragraph. Okay. There we are. So we're in paragraph 14, our favorite paragraph, which has most of our hiccups and issues in it. And 14D talks about buyer right to cancel. 14E.
Gary, all I'm seeing over here is the car cover page for zip form.
Oh, okay. Let me stop share and see if I can go back to it. Is that better?
Yep, perfect. Thank you.
Oh, okay, sorry. Sometimes when you switch those forms, they don't track in the Zoom. So anyway, we're in 14E, notice to buyer or seller to perform. The notice to buyer or seller to perform shall be in writing, be signed by the applicable party. Give the party at least 2 days after delivery to take the applicable action. The notice to buyer to perform or seller to perform may not be delivered any earlier than 2 days prior to the scheduled performance day. And it says, so that's about preparing the notice of the buyer to perform. So the seller's right to cancel is covered in paragraph C. So the question was, the agent was representing the buyer, was concerned the seller might give the buyer a notice to perform because the contingency date was coming up, and that the buyer may not respond to that. And then those 2 days would expire and the seller would cancel. And the question is, would the seller have a right to keep the deposit as opposed in that circumstance, as opposed to a circumstance where the buyer canceled first under the contingency clause, and it's clear that the buyer would get their deposit back in that case. Well, at least contractually clear. It's we have cases where the seller tries to hold on to the money even though the contract says they shouldn't. But if everyone's following the terms of the contract and the buyer cancels within their contingency period, they get their deposit back. So the question is it better that if the buyer is thinking of canceling, that the buyer cancel first, as opposed to letting the seller cancel, is the deposit in jeopardy? So let's look at the seller's right to cancel. Seller, after we're looking at 14C2 here. Seller, after first delivering the buyer a notice to perform, may cancel this agreement by the time specified in the agreement if the buyer does not take the specified actions, and then remove their contingencies and so forth. And then it says, seller shall authorize the return, down here at the very bottom, in this agreement. In such an event, that the seller cancels validly under those terms above. This is the last sentence in this paragraph. Seller shall authorize the return of the buyer's deposit except for fees incurred by the buyer and other expenses already paid by the escrow holder pursuant to the agreement prior to the seller's cancellation. So it doesn't matter. The seller's obligated to return the deposit. If the seller cancels, the buyer is entitled to the return of the deposit if the buyer cancels. It's kind of, the deposit doesn't get affected one way or the other.
That's if it's canceled prior to the end of the contingency,
Right, right.
which is actually rare. I mean, we usually, have conversations
Yep.
and work with the other group if they're having a problem.
Yep. Yeah, I mean, that's part of our job is to kind of iron out the issues that are keeping the buyer and seller moving forward on the transaction.
Right.
We, in the same transaction, the reason the buyer may not be prepared to remove the contingencies are twofold. They haven't gotten an insurance policy yet that's satisfactory to them. And there's an issue, there was one other issue that's outstanding, okay? So, very often we say, okay, let's ask for an extension of your contingency period on those particular items, and remove the rest of the contingencies that you can. And that's always, the seller likes that. You're still moving forward. You just have a couple items to clean up still, and everybody knows what they are. So that's very often the way we go when they're continuing contingencies that need to be addressed. So thank you, Sharon. This happens to be Curtis's transaction, so he's chiming in here, which is good. But there's also, this is a very curious issue because I've talked about it before. This is a vacant land parcel, so it's on a VLPA. But I think the VLPA has the same clause that the RPA has about condition of property. And that is that the property should be delivered in the same condition as when the buyer goes into contract, right? And I've talked about the scenario where we had a buyer go into a contract on a very nice home in Napa, and during a 30, 40-day escrow period in the heat of summer, this was a home that had very nice landscaping, and irrigation system and so forth and so on. Well, during the course of the escrow, 30, 45 days, whatever it was, the seller turned off the irrigation system and the landscaping went to hell. So, when we came through for the final walkthrough, it was like, whoa, what happened to the beautiful landscaping? It kind of got burnt in the heat and died. So we had to kind of negotiate some kind of settlement around that. In this particular case, we've got vacant land, and this is a long-term escrow, 60, 90 days or something. And, we know how it went. We had all that rain, and then what happened? All the grass and weeds grew, right? So now we got, when the buyer first saw the property, and they're in Florida, they're looking at a meadow, bare meadow, that's, looking, okay, everything. And now that you got 4 foot of weeds on the property, to the extent that the county is making a demand to the owner for under the weed abatement laws that govern the county of Napa. So, I mean, does the growth of weeds like that constitute a violation of that clause that the property shall be delivered in the condition at which you bought it? I've never had the question before, so I'm not really sure. And I don't know, you probably get a couple of lawyers who would argue both sides of that issue if you got down to it. So it's again where we play a role as an agent to try to kind of mediate these things, to try to negotiate these things. So the question we've come up with is, maybe the buyer writes an RR at this point, and then when they're removing their contingencies, that they'll remove the contingencies subject to credit for the weed abatement. And the weed abatement, I don't know, it could be several $1,000s in this case. I don't know how much, but yeah, they negotiate on that as it, rather than argue about who's technically responsible for it. Why do you find, part of our job is to find a solution that works for everybody. So that's where we are with that. But it's an interesting question from a technical point of view. Does the growth of something on the property constitute that it's not the same as the when the buyers went into contract? Okay. I think that's about all I have today. Was there anything more in the chat? Okay. Not having anything else to cover, unless there's any questions, we'll kind of let you all go a little early today.
Gary, I had a question.
Okay, Eric.
I've got a client that just sold a property and they're going to be buying another property and they want to carry their tax basis forward. What's a good source of information on that, and what bill is that?
Well, you remember that little scenario we went through with the CAR here. We'll do it one more time. Let's go. Let's see, find CAR home here.
Hi.
Sorry, perfect timing, I guess.
Okay. Let's see. Can you see the CAR page now? Somebody tell me yes or no.
Just the front page.
Yeah.
You're going on Transaction Center, yeah.
Yeah, okay. So we're going to the Transaction Center, we're going to Risk Management, we're going to Legal Q&As, and we're going to scroll down to, let's see, taxes, real estate taxes. Tax. So these are all tax things, capital gains tax. We have a question right now. We have a client that's thinking of selling their home, and their CPA is retired, but before, I'm not even sure they were CPA, but their tax advisor retired, but before he retired, he told them that, oh, you can add all those improvements you made to your house, you can add them to your tax basis before you calculate your capital gains. Is that correct?
I would not think so, but I'm not sure.
No, that's how it used to be back in the good old days. You can't do that anymore. So you just get a flat $500,000 for a married couple and $250,000 for a single couple. But then anyway, that would all be in this capital gains tax area. Home buyer tax credit, internal revenue, tax assistance for tax cuts and tax. I'm sure that somewhere in here, property tax assistance for property tax exemptions for reassessment and property 19. So if you went into there, Eric, I'm sure you're going to get an answer about your you're transferring your tax basis. sale and replacement of principal residence and so forth. So that's where you want to go.
Prop 19.
Yep. Yep. It's all related to Prop 19, and that was updated in 2021 when they changed that law most recently. So,
Good, thank you.
yeah. The other thing was it's this couple that owns that may be thinking of selling their home are moving to Nevada, and they wanted to transfer their real estate tax basis to Nevada. And said, no, that doesn't work. The law did change where you can transfer it between counties in California, which is great. And good luck with your listing, Amy. But yeah, you can't transfer your tax basis out of state. And the last thing that came up with them is, so when they take their 500,000 deduction on the gain they've had in their property since they owned it and, for 25 years, their gain is actually about $800,000. So what happens to the other $300,000? Well, that would be a question for a CPA, or you could research it and send them. You can send these Q&As to your clients. I've often done that. There's a link and you just send it to them and let them read it. You don't interpret it. But yeah, the question that came to my mind: can they take a second note on that property for the $300,000, carry a second, and treat that part of it as an installment sale? And I'm not sure you can do that with the residential property, yes, but I mean, I know you could do it with commercial sale, or if you had rental property. I'm not sure the installment sales refer to residential. Curtis says you can, and I did it. So Curtis did it.
We'll trust Curtis.
Maybe you can too, but yeah, I wouldn't take Curtis's word for it. I would research it further. And probably in that same area about transferring your, capital gains that we were looking at in the CAR Q&A, there's probably an answer to that question about installment sale on residential property.
Garrett, I have a question that's just for mobile home purchases in parks. Came to my attention. Sharon actually posed it to me because the park that we sell in the most, the state, the HCD has an inspection, a Title 25 inspection on their books, and they're for the parks and for individual residents. And they seem to leave it up to the ownership of the parks, whether they're going to do something with it or not. So Rancho San Miguel has done that like 2 or 3 years ago, where they made it mandatory for a new resident to come in to have this inspection, and seller must clear all violations before a resident can come in. So the question put to me was, the contingency that is in the mobile home purchase addendums is a contingency for park approval, but that's for the buyer being approved. So now the seller actually has a requirement for approval. And does there need to be anything further in the documentation to cover that at all?
Well, if it's a requirement placed on the seller by the park itself. Yes. I don't think if we could write in our buyer's offer. In fact, I bet it's covered in the language of the buyer's offer somewhere in the RPA. I'll research and see which paragraph. I bet there's a paragraph in the RPA that says the seller shall do everything that they have to do according to law to get the property sold.
I thought it would be a seller's contingency. Because it has to be done before you can finalize the sell.
Oh, I thought it had to be done before the property goes to market.
No, it has to conclude by the close of escrow.
So what do? I'm in escrow in Rancho San Miguel.
Yeah, I thought you'd enjoy that, but you got out
You
already.
got my attention for sure.
Yeah, I figured as much.
I will look in the RPA later on today, and I'm sure there's a clause in there that the seller is obligated to do what they're obligated to do by third parties. You know,
Okay.
it's like when there's certain cities that have seller requirement, point of sale requirements.
Right.
San Rafael, Cotati are the ones I'm.
Right.
And
All
so
over Marin.
obligated under those laws to conform to them.
Yeah,
And the contract, the RPA, somewhere in there, there's RPA language that says the seller is obligated to do those things.
Okay.
So I will check on that and confirm with y'all.
Okay.
Hey,
Thanks.
Garen,
Yes.
I had a similar situation where I was representing a buyer
Right.
and it was in the town of Ferndale, and it is required to have the seller provide a sewer lateral certificate. So
Yeah.
this was a city ordinance.
Right.
So at the last minute, the seller did not even know about this requirement and said, well, I'm not going to pay $5,000 and I'm going to back out of the deal. So I called the CAR legal hotline.
Uh-huh.
And the very first thing that the attorney asked me, she said, read me in the contract where you have that stated that the seller has to provide a sewer lateral. So I read her. I had checked the box that says that the seller is to provide all city ordinances. And then under the line there, I wrote in sewer lateral clearance. And she said, okay, because you have that written in there, the seller is obligated to do that. So in this situation, you could write in what that ordinance is, whatever it may be, under
Right.
seller to pay for that.
Right. Okay. I'm just gonna go, yeah, that might be right there in the grid. Let's just check the RPA real quick. And you would need to check that box. Perhaps, or it might be default. Let's see. All right, I'm going to go back to share screen again and see if we can. Okay, you see the agency disclosure there?
Yes.
Okay. So. Government required point of sale inspections reports. Government required point of sale corrective or remedial actions. So these are choices here. And I don't know if that's an interesting question, whether the park would be considered a government.
Yeah, that was why I thought it wouldn't float into this, is because it's not a city or a county or anything requiring it. The park itself is requiring it.
Yeah.
actually, it's HCD is government.
HCD is government, but that's not who's making it mandatory.
Yeah.
The park itself is making it mandatory by holding off the residency change.
Yeah. That's good. There's a question whether that might even be legal, but
Yeah, well, there is gray area with the HCD, that's for
Yeah,
sure.
All right, Rob, you're on your own. No, I
Great.
you might write now that you're aware of this, you might write an amendment to the contract to incorporate that the seller is going to complete that as required by the park.
Okay. We have removed physical inspection contingency. Can we
Yeah.
still put that in at this point? Okay.
Oh, yeah, you could still add an amendment, with that kind of language. Yep.
All right, I'll do that.
Yeah, and if you're, you run into those things with HOAs and parks like that, they have special requirements and until we learn about them, we're kind of, it's a good we share the knowledge and in the future, I would write my contracts in that place to include that provision.
Yeah, I absolutely will. This is my first mobile home actually, so it's a
Yeah.
baptism by fire, but I
Yeah,
will
right,
definitely do that.
right.
So
right.
Garrett, would you think that something needs to be done from the sellers, from the listing, on the listing side?
No, I mean, if you're aware of it as the buyer's agent, I would write it into the RPA.
No, I mean from the listing agent, because I list in that part.
Oh, well, I would certainly make sure that the seller is aware of that requirement, like.
Yeah. Oh, yeah.
Steve was talking about that seller in Ferndale didn't know anything about that lateral
Yeah.
ordinance. So, you know, that is up to the listing agent to instruct the seller of that. And
Right.
Make
Yeah,
sure.
exactly. Exactly. Yeah. But it's really something that a buyer's agent would want to make sure that that is taken care of. Yeah.
Yeah. Yeah.
Yeah. Okay. Wonderful.
Okay.
Thanks.
Thanks for bringing up the information.
That's Sharon.
Sharon. Okay.
She's a good researcher, thinker. Okay.
All right, y'all. Have a good week, good weekend. Enjoy the weather.
Okay. You
Okay.
too. Bye-bye.
Bye-bye.